Good afternoon, and welcome to this public meeting of the Standing Committee on Social Development. My name is Jane Wayellen Armstrong, and I am the MLA for Mofi and Chair of the Standing Committee on Social Development. Today, we are joined virtually by the Honorable Minister of Justice R.J. Simpson and departmental officials to receive a briefing on Bill 2 Missing Persons Act. Bill 2 Missing Persons Act received second reading in the House on February 26, 2024. This committee has been tasked with reviewing the bill to see if it needs any changes, if it has any issues we can solve, and if it is ready to continue on its path to becoming a law. This committee is starting off its review of the bill by hearing from the sponsor of the bill today. Please note this meeting is being live streamed to the Assembly social media channel. I will now ask members to introduce themselves for the record, starting with to my right.
Okay. Shauna Morgan here, MLA for Yellowknife North.
Cheryl Yacoad, that's your MLA. Thank you.
And Mr. McNeely?
Yes, thank you, Madam Chair. Danny McNeely, the MLA for the Sawtooth. Good afternoon, Premier.
Thank you. I will now pass it over to the Minister to introduce your staff and proceed with your remarks and briefing. Please proceed.
Thank you, Madam Chair. Thank you to committee. I'm pleased to be here today to discuss Bill 2, a Missing Persons Act. I want to acknowledge as we begin that my thoughts and those of the department staff who worked on this bill are very much with the families and friends who have experienced the disappearance of a loved one. Bill 2 proposes new legislation that will provide additional tools to assist police in investigating reports of missing persons. Today, I'm joined by a number of individuals from the Department of Justice: Brad Patzer, Assistant Deputy Minister, Attorney General; Mandy Bolstad, Assistant Deputy Minister, Solicitor General; Christina Duffy, Director of Legislation Division; and Mike Argue, Director of Policy and Planning Division. And as always, my Ministerial Special Advisor, Ronna Sherigan, is also with us. Madam Chair, during the 19th Legislative Assembly, the Government of the Northwest Territories committed to developing this legislation in response to Call for Justice 5.8 from the National Inquiry into Missing and Murdered Indigenous Women and Girls. The Northwest Territories does not currently have missing persons legislation in place, and this can slow and sometimes completely halt an investigation for a missing person in cases where there is no evidence of criminal activity. Most Canadian jurisdictions have passed missing persons legislation. These laws allow police to seek court orders to access records and to enter premises to search for missing persons, as well as to make emergency demands in certain situations. Bill 2 operates similarly and would allow police to move quickly in their investigations, while at the same time providing for oversight and accountability when police are utilizing the powers provided for in this legislation. The Department of Justice engaged broadly during the development of Bill 2, including with Indigenous governments, community leaders, the RCMP, the Department of Health and Social Services, the Director of Child and Family Services, the Office of the Information and Privacy Commissioner, and with members of the general public. The feedback we received has helped to shape the legislation under consideration here today. Thank you, Madam Chair. This concludes my opening remarks. I have kept them brief as Mr. Patzer will be providing a presentation that includes more detail on the contents of the bill and its development. And following the presentation, I'd be happy to answer any questions that members may have regarding Bill 2. And so through you, Madam Chair, I would like to pass it to Mr. Patzer for the presentation. Thank you.
Thank you, Premier. And so I'm just briefly filling in for Emily Whalen Armstrong as she dips out and comes back in, but we're happy to pass it along to Mr. Patzer to give us the more detailed briefing on the bill. Thank you.
Thank you. Can everybody hear me okay? Excellent. Thank you for that. I understand somebody will be operating the presentation as we go along, and I will ask that the pages advance as we go through. So the next page would be excellent. Thank you very much. Good afternoon. I'm pleased to be here today to provide this briefing on Bill 2, a new Missing Persons Act for the Northwest Territories. I will be providing a brief overview on the purpose of this type of legislation, some information on steps taken during the development of the bill, as well as a summary of key aspects contained within the bill itself. Next slide, please. As a general overview, missing persons legislation is intended to add to the investigative powers the RCMP have at their disposal when undertaking a missing persons investigation. Currently, without this legislation, when police begin an investigation, they often have no reason to suspect that a crime has been committed, and therefore cannot obtain a production order under the Criminal Code of Canada, nor otherwise compel parties to release personal information about a missing person. This can stall and sometimes completely halt an investigation. Most missing persons legislation in Canada allows for police to obtain court orders that allow them to access records and enter into a premises to search for a missing person. In certain urgent situations, provisions also allow the police to make emergency demands without a court order. This legislation is intended to allow police to move quickly with their investigations when time can be of the essence. While providing for these additional powers, it is important to ensure that an appropriate balance is struck in maintaining safeguards around individuals' right to privacy and accountability to ensure that mechanisms for its use are in place. The need for missing persons legislation was highlighted by Call for Justice 5.8 from the National Inquiry into Missing and Murdered Indigenous Women and Girls, which directed provinces and territories to enact such legislation. In December of 2021, the then minister responsible for the status of women tabled an action plan entitled Changing the Relationship, the GNWT Draft Action Plan in response to the calls for justice. In that action plan, the Department of Justice committed to developing this legislation. Next slide, please. The development of the bill. Work towards the development of the legislation began during the 19th Legislative Assembly. The department undertook a jurisdictional review of missing persons legislation in other provinces and territories to develop an understanding of the nuances of this type of legislation. For a 6-week period beginning in July of 2022, the department advertised and undertook public engagement. Residents were invited to share their feedback through an online survey or by providing written submissions. The department reached out directly to all Indigenous and community leaders, as well as to a focused number of stakeholders, which were identified as potentially having particular interest or insight in related areas. The department released a What We Heard report in July of 2023, providing an overview of the engagement results. The report emphasized the importance of developing missing persons legislation, and the info received directly contributed to the form and content of the legislation. Search orders, record access orders, and emergency demands were all widely supported. It also emphasized the importance of privacy safeguards, such as limiting information that can be accessed or publicly released. As work to draft the Missing Persons Act was underway, the department consulted further on specific points of the draft legislation with the RCMP, the Office of the Information and Privacy Commissioner, the Director of Child and Family Services, and the Department of Health and Social Services. Multiple rounds of discussion delayed the introduction of the bill. However, this did allow us to ensure fulsome consideration was given to the feedback provided by those who would be working to operationalize the various aspects of the legislation. Next slide, please. The bill deals with 10 core aspects. We will go through each of these categories on a point-by-point basis. You'll notice as we go through these that there are some overlapping issues at play between each of the points. Next slide, please. Most legislation in this area contains a section on definitions and interpretation, and there's no difference with this act. There are multiple definitions in the Missing Persons Bill. However, perhaps of most interest is the definition of a missing person. In a theme you will see repeated throughout this presentation, there was a need to strike a balance between ensuring that the legislation was limited enough to avoid providing unreasonable access to personal information and searches of premises to police, while at the same time not limiting the definition so much that it became ineffective at providing access in instances where it might be of critical importance to aid in an investigation. For example, consider a situation where there is someone whose specific whereabouts are unknown, but who is known to be on the land with no easy form of contact available, but they have a set date and time of return that has not yet been reached. It would not be reasonable to access someone's private records simply because they cannot be immediately contacted. This definition prevents this type of overreach. On the other hand, the definition does allow for consideration of a wide variety of circumstances under which someone may be considered a missing person, and the legislation could be utilized in each of these cases. Next slide, please. Record access orders and search orders, along with emergency demands, are critical to the functioning of the Missing Persons Act. Record access orders allow the RCMP to access records that may have information related to the whereabouts of a missing person. Search orders allow the RCMP to enter a specific location to look for a missing person. A member of the RCMP can also apply for a record access order or a search order, or both. For record access orders, the RCMP need to show that there are reasonable grounds to believe that the records are in the custody or control of the person to whom the order is to be served, and that the records will assist in locating the missing person. For search orders, the RCMP need to show that there are reasonable grounds to believe that a missing person may be located at the premises and that the authorizing entry is necessary to ensure their safety. In both cases, the court can impose terms that they believe are appropriate. In both cases, the court also needs to be of the opinion that the public interest in locating a specific person outweighs the privacy interests of those who may be impacted, and must also consider whether there is any indication that the missing person does not want to be found. Next slide, please. Emergency demands. A member of the RCMP can make an emergency demand in writing for people to disclose information under some limited circumstances. Emergency demands are useful in time-sensitive cases. Missing persons cases are often time-sensitive, especially in cases involving vulnerable people and in the cold northern climate. They are meant to be used in cases where a record access order would take too much time or where someone might destroy records before the court orders them to be disclosed. Although these demands are not put before the justice or the court, the member making the demand is subject to the same requirements as the court in determining that the public interest in locating a specific person outweighs the privacy interests of those who may be impacted. And they also need to consider whether there is any indication that the missing person does not want to be found. Using an emergency demand does not prevent the RCMP from making a record access order later, should that prove to be of potential aid in an investigation. The RCMP will be required to notify people whose information has been produced under an emergency demand, and the process for this will be laid out in further detail by way of regulation under the Act. While this may take more resources, people have the right to know how much of their personal information was accessed using this tool. Next slide, please. Access to records can be an important aspect of missing persons investigation, which is why we have provided two tools to do so, both by court order and by emergency demand. Records can include items as diverse as contact information, GPS records, school attendance lists, or security camera footage. Even though it is important to get records quickly, even records requested with the best intentions might lead to a privacy concern for an individual. We have limited the types of records that the RCMP can ask for in an emergency demand situation to protect the privacy of those involved. For example, when making an emergency demand, the RCMP cannot obtain any health records except for whether a missing person was recently admitted to a hospital, and if they were, the date, time, which hospital, and the reason for admission. For more detailed medical records, the RCMP must apply to the court for an order, which allows an oversight on whether access to these records is in fact necessary, or if it may unjustifiably intrude upon an individual's privacy. This limited scope for use of emergency demands introduces an additional oversight over sensitive private information. Next slide, please. Factors to consider. There are factors that need to be considered in providing access to records. The first is that the public interest must outweigh the privacy interest of any individual whose records will be accessed. This is common language in missing persons legislation and at the Federal Privacy Act, and in the Federal Privacy Act, This ensures that privacy interests must be considered and that we limit the scope of personal information that is accessed to that which is reasonably necessary. The second is that they must consider whether a missing person may not want to be found. We heard repeatedly and saw in other jurisdictions similar concerns that consideration should be given to the instances where people may be fleeing violent or abusive situations. Some people are just actively trying not to be found. We wanted to ensure the legislation is not used as a tool for abusers to locate individuals. This consideration does not prevent the RCMP from making a demand or the court from issuing an order, even if they think the person does not want to be found. It does, however, require the RCMP and the courts to consider all circumstances surrounding their disappearance before granting access, including the potential that the missing person may or not want to be located. Next slide, please. Restrictions on use. Significant personal information can be collected under the Missing Persons Act. While collection of that information may be necessary to aid in the investigation of a missing person, territorial residents also have expectations regarding their right to privacy. We have created careful limits on the use and disclosure of information. There are certain cases where we cannot limit use of information, such as where an obligation exists under federal or Northwest Territories law. We also wanted to ensure that police were not limited in sharing information across borders where it might aid an investigation about a missing person. It is possible that a Northwest Territories resident might go missing in Alberta. It is important to ensure that we can cooperate with police in other jurisdictions to bring them home safe. In some circumstances, an individual may consent to the use of or release of specific information about them. Some limited information will be utilized in the preparation of an annual report, though no identifiable personal information will be included in that report. Next slide, please. Public disclosure. It is important that only necessary information about a missing person is disclosed publicly. Prior to locating the missing person, the RCMP can disclose information about the missing person that they believe will help to find them. This can include specific and personal details such as physical identifiers, time and location last seen, and some information about medical conditions, although they may not disclose the medical condition itself. After a person is located, the RCMP are far more limited in the information they can disclose. This is because it is no longer necessary to disclose information to protect their safety or the public interest outside of the very limited set of circumstances. Next slide, please. While drafting Bill 2, the department considered interactions with other legislation. Territorial law cannot supersede federal law, and for that reason, federal legislation such as the Federal Privacy Act and the RCMP Act will continue to apply, and relevant organizations will continue to be governed by those acts. Bill 2 explicitly does not limit the authority the RCMP has under the other legislation. The Act also does not compel the disclosure of any privileged information. Significant attention was paid to respecting processes under other territorial legislation and tailoring processes to avoid unnecessarily undermining other privacy protections. While this Act does apply in cases of inconsistency with ATIP or under the Health Information Act, the bulk of processes under these acts are maintained except for in the limited circumstances of missing persons. For example, requiring a court order for disclosure of most medical records and records relating to services under the Child and Family Services Act is keeping in line with existing processes under our other privacy-related legislation. Next slide, please. There are 3 offense categories in the legislation. Failing to comply with a record access order or an emergency demand is an offense, as is obstructing a member from carrying out a search order. The penalty is a fine of $10,000 for an individual or $25,000 for a corporation, and an additional fine of up to that amount may be added for each day an offense persists. An individual who makes unlawful use of information or records collected under the Act is also guilty of an offense. This offense may apply to police, but it does not apply if an officer or another person has acted in good faith. The penalty for this is a single fine up to $10,000. The fine amounts are high. However, this is intentional due to the serious nature of the offenses. Failure to comply or obstruction could lead to additional harm or even death of a missing person. Unlawful disclosure, on the other hand, could lead to significant privacy breaches for an individual. Next slide, please. Accountability. Bill 2 includes several components designed to ensure accountability. This includes an annual report that will be prepared by the RCMP and made available to the public. The report must contain the total number of emergency demands, the total number of missing persons investigations those demands related to, a description of the records specified, and any other information that is laid out in regulations under the Act. The report cannot include any identifying information. As discussed during the previous slides, offense provisions exist to ensure accountability among those with access to personal information under this Act, as well as the requirement for individuals to be notified when their information has been accessed on an emergency basis. Next slide, please. Regulations. There is a power to make regulations under this Act. The regulations can include additional details of what is required for inclusion in the annual report, the process for providing notice to individuals whose information has been accessed on an emergency basis, and standardized forms for requesting information that must be used. Should Bill 2 receive assent, the department is prepared to advance work on the necessary regulations to bring the Act into force as soon as reasonably practicable. This concludes my overview of Bill 2. We would be pleased to answer any questions that you may have. Thank you.
Thank you. Thank you for the presentation. I will now ask members if they have any questions. Anybody? Okay. Ms. Yakalaya?
You asked about their information. Question I had is personal information. What personal information? I didn't read the Missing Persons Act, but the personal information, is this their ID and is this their ID? Is that?
Okay.
Or are you using something like, say they're doing a job search for this in the South or somewhere? Is that personal information going to be collected? Thank you.
Mr. Platzer?
Thank you, Madam Chair. The Act itself speaks to what access orders may speak to. In Section 7, Sub 2, it identifies records containing contact or identifiable information, telephone records, other electronic communications, GPS tracking records, video records, if there is any, records of employment information, records of personal health information, records from a school, university, or other institutions, records containing travel and accommodation information, records containing financial information. Those are the typical types of records that would be sought when seeking a missing person. The Act itself doesn't speak to other kinds of records, just those specified in Section 7, Sub 2.
Okay. Any more questions? Okay. Ms. Morgan?
Thank you, Ms. Chair, and thank you, Mr. Patzer, for the presentation. One question I have is around how to balance both the danger that someone is going to be sort of revealed or outed if they are trying to hide or not be found, and then also requests often by family members that they want updates on the RCMP investigation and where it's at, and want to be kept informed by the RCMP. So can you explain how this Act would balance the possibilities on both sides and could potentially be responsive to family members who are wanting updates, but also still protect the person in case they do not want to be found or are fleeing, say, an abusive situation?
Okay. Minister Simpson, do you have any question to answer that? Or?
Yes, I do, and that information is located in Section 13.4. So Section 13. So the RCMP, they may disclose to the public only the following information: that the investigation is no longer a missing persons case if the individual was found, or the fact that the missing person is deceased. But if a missing person who is located consents, then the RCMP may disclose information about that missing person to facilitate contact between the missing person and a spouse, a relative, a friend, or acquaintance. So if the missing person is found by the RCMP, they have the ability to say, no, don't share my information. I don't want this person to know where I am. In the case of a minor, the RCMP do have the ability to disclose information if they reasonably believe that disclosure will protect the safety of the minor. Thank you.
Okay. Yes, follow-up? Ms. Morgan?
Thank you for that. And so does this mean that the RCMP has no power to update family members as an investigation is underway? So if the person hasn't been found yet and they haven't consented to share, the status or location, but family members are wanting an update on, have the RCMP made any progress? Do they have any leads? Does that mean that the RCMP has no ability to share any updates along the way with family members because it sort of errs on the side of no information about the status of the investigation is shared until the person consents, meaning you've found the person? Is that clear, the question?
Mr. Simpson? Minister Simpson, sorry.
Thank you. So if a missing person is not found, this act does not prohibit the RCMP from updating the family as they currently do. It would not have an impact on that. The RCMP can continue to work with the family to provide updates to the family. It's only in the instance where the person is found that it is then using this information that is then governed. But no, that won't impact the RCMP's ability to update the family on ongoing investigations. Thank you.
Yes, Ms. Yakalaya.
Thank you, and thank you for the presentation. In the case of a minor, wouldn't that information be automatically released to the next of kin or the parents? That's a question I have. Thank you.
Minister Simpson?
Sorry, thank you. That's a little outside the scope of this bill or what's contained in this bill, so I would have to hand it off to see if Mr. Patzer might have some information on that.
Mr. Patzer?
Thank you, Madam Chair. I guess the only thing I could add to that is that it is outside of the scope of this legislation, but the legislation does speak to the fact that the RCMP would then be able to go to the third party and seek the information, whether the parents do or not. Thank you.
Thank you. Ms. Yakalaya, do you have a follow-up?
So there's nothing to say that the RCMP will notify the parents or the next of kin that's in charge of the young person, or is that correct? Or thank you.
Mr. Patzer?
No, the act does not require notification. To the extent that there is notification, the documents filed in an application before the court are public documents, so there would be the ability to seek the information there, but there's no notification requirements in the case of a minor in the legislation as it currently stands. Thank you.
Okay. Minister Simpson?
Thank you. So just to be clear here, what we're talking about is the information collected under this act and the ability to disclose that information. So what this act states is that the RCMP may, without the consent of the minor, disclose any information about the minor collected under this act if they reasonably believe the disclosure will protect the safety of the minor. So it doesn't speak to an RCMP investigation into a minor and then returning that minor to the family. It just speaks to the information collected under the act. Thank you.
Yeah, okay. Okay, now that I do have a question as well. I just want to ask, what is the definition of imminent danger? Dangers. Minister Simpson?
Thank you. I don't have that at my fingertips. Can you let me know what section that is in? What section you're referencing?
Okay, it is regarding the act, the imminent dangers, it's in there, so. Thank you.
All right, I don't have a definition. Perhaps we can add to Mr. Pastor to see if he has one. I will quickly scan the legislation to see if there is something that indicates what it is.
Thank you, Premier. I don't recall which section that may be used in. Sorry.
Okay, okay, but it is in there. Ms. Yakalai has another question, and I will go back and ask another question as well at the end. Thank you.
Thank you. If a person was missing, say, they went missing like 5 years ago, does this legislation, is it going to be starting from now, or can we go back and use this legislation to, like, can people go back to the RCMP now and say, well, we have this new legislation, can we now use that to find the missing person from, say, 10 years ago or 5 years ago? Thank you.
Minister Simpson?
Yes, this legislation is applicable to persons who went missing prior to the date that it comes into force. Thank you.
Ms. Yakalai, do you have a follow-up?
I guess the information that they, like, some people might decide to change their name, they don't want to be found, so vital statistics would be where you would find information to, that's correct?
Minister Simpson?
I'm not sure. I mean, it's very dependent upon the type of information. So it's really hard to say. It's hard to answer the hypothetical, but the government of the Northwest Territories is bound by this act. And so the RCMP could make an application for an order for that type of information. Thank you.
Okay. Thank you, Minister Simpson. Shauna, Ms. Morgan?
Thank you. So under the compliance and penalty section, how long would an individual or an organization or corporation have to comply before they would start being penalized if they didn't provide the information requested?
Minister Simpson?
Thank you. And I believe that it is, I guess it would be contextual. Sorry, I'm just flipping to that page right now. I believe it is as soon as practicable. And so it would depend on the information, how it is stored, where it is stored, how easily accessible it was. And so I don't really have an answer on the number of days. If a request for information is made, the person has to be given a reasonable amount of time to get that information, understanding that it is urgent. It's not, they'll get to it when they can. There has to be some effort put into it, but perhaps I can see if Mr. Patz or anyone else might have a better answer. Thank you.
Ms. Morgan, do you have a follow-up? Oh, okay. Mr. Patzer, do you want to add to that? Thank you.
Thank you, Madam Chair. The only thing I would add to that is that it is open to the court to impose terms and conditions that are reasonable in terms of any order that's issued under the Act. So at times, I see it foreseeable that there could be a time frame laid out in the court order within which they must comply. And I'm sure if that wasn't practicable, as the minister said, the court could be, I guess, tasked with determining what would be a reasonable time if the party couldn't comply within the stated time frame in the court order.
Thank you. Miss, if there's no other questions, we'll go back to Ms. Yakalai.
Thank you. Jurisdiction, the jurisdiction, is that only in Canada, or are we looking in the United States or other countries? Is that how this is going to work? Thank you.
Mr. Simpson? Minister Simpson.
Thank you. Thank you. Either one works. So this applies in the Northwest Territories. Other jurisdictions in Canada have their own legislation, and there is cooperation amongst police forces. And so information obtained, as Mr. Patzer alluded to in the introductory presentation, there could be sharing of information between jurisdictions, given that people do cross borders. I will note that it does not apply to the United States of America or other countries, and there have been, I think, difficulties getting information out of some American corporations, things like Facebook. It is not a straightforward process, and we cannot use this legislation to compel them to provide information. Thank you.
Thank you. Ms. Yekela, do you have a follow-up? Ms. Morgan?
Thank you very much. So, when there's reference to, loved ones or main contacts in the legislation, like deciding if someone's missing, have they contacted loved ones or main contacts for a certain period of time, or in terms of disclosure to loved ones, is there a way to, like, criteria for how someone would qualify as a loved one or a main contact? Like, how would the RCMP decide whether this is a legitimate person that we should be sort of taking seriously or disclosing information to?
Minister Simpson?
Thank you. And I understand there may be a briefing with the RCMP on this, and so they might be the better ones to direct that to. But I will say that I believe that 11 jurisdictions or 10 jurisdictions in Canada, or 11 jurisdictions currently have missing persons legislation. And so there is this case law surrounding this. And so that could be help inform that as well. But Mr. Patzer, once again, might have more information than I do. Thank you.
Mr. Patzer?
Thank you, Madam Chair. The only thing I would add to that is the Minister is correct. The RCMP might have more context, but in addition, I think every situation is going to have to be looked at by the RCMP and the context of the person's life, who the individuals surrounded themselves with on a regular basis. And at the end of the day, it will be up to a court to determine that A, this is a missing person, and B, that the request for information is reasonable in the circumstances. Thank you.
Thank you. Ms. Morgan, do you have a follow-up? Yes. Okay.
Thanks. I had one more question, and this is on a different topic, but the reporting mechanism, the annual report, one part of the question is, do we currently have any statistical information or reporting on missing persons in the NWT that is published either by the government or others? And would the proposed annual report in this Act provide some kind of statistical analysis or overview of sort of what's happened over the year and in terms of missing persons?
Minister Simpson?
Thank you. So I believe what is required by the Act is just reporting in relation to the emergency the provisions. So not even the ones that go through the courts. But I'm not sure if there is anything publicly reported about missing persons. I'm not sure if Mr. Patzer knows or if anyone else on the call has any information on that. But thank you, Madam Chair.
Okay. Mr. Patzer?
The only thing I would add to that, Madam Chair, is that the regulations also, the Minister is correct, there are reporting requirements in the Act with respect to emergency demands. But in Section 20, the regulations making section provides the authority for requesting that additional information be provided in the annual report in terms of statistics. I think the only restriction is that obviously the annual report can't contain any identifiable or personal information. As to any existing reporting now by the RCMP in this area, I do not have that information. I'm not sure whether Mandy would or not, but I do not. Thank you.
Okay, I do have a question too as well. So even when this legislation comes into force, how does the government intends to educate the public, especially with the organizations and businesses that may need to provide information on the missing person about this act? Thank you.
Thank you. So I don't believe at this point there is, and I could be wrong, but I don't believe there's a communication strategy yet for this bill, as it has not yet passed and could change. But there has been plenty of education about it so far. I mean, it's appeared in the media quite a bit, but ultimately, if an RCMP shows up with a court order requiring something from an individual, that's pretty self-explanatory, and hopefully the public will understand that and be able to cooperate. Thank you.
Okay, thank you. Do we have any more questions? Because this is an important legislation. We still have quite a few outstanding cases that, I mean, it will benefit the families, the family and friends out there. So it is important. It is important legislation for us. So if there's any more questions, if there's no more questions, then we'll conclude. Okay, if there's no more questions, then I would like to say thank you to the minister and to his colleague for the presentation to the members.
Thank you, Madam Chair, and thank you for the committee's interest in this as well. As you said, it is a very important piece of legislation. Thank you.
Okay. Okay. Thank you. Okay, if there's no more questions, then we conclude the public portion of this presentation. Thank you.